In today's video, we revisit 5 of the most severe death penalty cases carried out in October, a month that shattered modern records. With 7 executions in just 31 days, October became the deadliest month in the entire history of the U.S. death row system since 1976. These weren't ordinary cases. They involved some of the most dangerous offenders ever scheduled for execution. Roy Lee Ward, State, Indiana, 53 years old, execution date. Roy Lee Ward was born in 1972 and grew up in an environment defined by instability, early behavioral problems, and a pattern of sexualized misconduct that emerged long before adulthood. By his teenage years, he was already exposing himself in public, harassing strangers, and developing the type of compulsiveness. As an adult, his criminal record expanded into a long string of arrests across multiple states: assault, burglary, theft, forgery, drug violations, stretching from 1990 to 2001. Nearly every year brought a new charge or investigation. Despite repeated interventions, he reoffended constantly, slipping through the cracks of several jurisdictions. Everything converged on July 11, 2001, in the quiet town of Dale, Indiana. That afternoon, Ward approached the Payne family home under the pretext of searching for a lost dog, gaining the attention of 15-year-old Stacy Payne. When he cut the house's landline phone, severing the only immediate connection to help, the violence began with terrifying speed. He forced his way in, armed with a knife and a 5-pound dumbbell, and launched a brutal attack that would leave even seasoned investigators shaken decades later. Stacy fought for her life. She remained conscious and aware through the worst of it, unable to speak but able to nod in response when help finally arrived. Her 14-year-old sister Melissa heard the screams from upstairs, called 911 from another device, and hid in a closet while listening to her sister beg for mercy. By the time Sheriff Matt Keller arrived, Ward was still inside the house, standing at the doorway covered in blood and gripping a knife. Keller ordered him down at gunpoint, and then discovered Stacy on the kitchen floor, gravely injured but still responsive. She died just hours later in the hospital. The forensic record was direct and airtight. Stacy's DNA was found on Ward's genitals. His blood was located at the scene. Every significant wound matched the weapons recovered from his hands when he was arrested. There were no ambiguous traces, no unexplained gaps, no mysterious profiles to muddy the chain of evidence. In a case already defined by its brutality, the forensic clarity left little room for dispute. What became contentious instead was everything that happened once the case entered the courtroom. Ward's first trial in 2002 ended in a death sentence, but the proceeding immediately drew controversy. Defense attorneys argued that the atmosphere surrounding the trial had been poisoned by massive pretrial publicity. Details about Ward's long history of indecent exposure, including uncharged or unproven incidents, circulated widely. Potential jurors had been exposed to material that would never have been admissible at trial, creating what his lawyers described as a climate of predetermined guilt. They argued that no jury in that county could remain impartial because too many prospective jurors already knew him as a long-term sensitive deviant before the evidence was ever presented. That concern escalated into a serious constitutional issue when the state's highest court reviewed the case. In 2004, the Indiana Supreme Court took the rare step of overturning Ward's death sentence entirely. The ruling focused on 2 major failures: the trial court's refusal to grant a change of venue and the overwhelming saturation of prejudicial pretrial publicity. According to the court, the community had been exposed to so much damaging information, much of it unrelated to the charges at hand, that it created an environment where no reasonable jury could be guaranteed neutrality. It was one of the uncommon moments in capital litigation where the influence of public opinion and media-shaped narratives was deemed powerful enough to invalidate a death sentence. The second trial in 2007 took place in a different county with jurors selected from yet another region to reduce bias. This time, Ward pleaded guilty to sensitive assault and murder, a move that puzzled many observers. Some attorneys argued that pleading guilty in a capital case stripped him of leverage he might have used to negotiate a non-death sentence. Yet Indiana law still required a full penalty phase, and despite the plea, the jury chose death once again. The sentence was upheld, cementing the outcome that would follow him for nearly 2 decades. From 2007 onward, the case became a familiar battle through post-conviction motions, state habeas petitions, federal habeas petitions, and an eventual appeal to the U.S. Supreme Court. That request was denied in 2017. In 2019, Ward filed a civil lawsuit aimed at halting all executions in Indiana, arguing that the state's lethal injection protocol lacked transparency and violated constitutional safeguards. Although the lawsuit drew attention as part of a broader national debate on execution methods, it did not alter the trajectory of his own case. Clemency proceedings in 2025 introduced a final layer of contradiction. Ward claimed that a learning disability and a speech impairment prevented him from expressing himself clearly, particularly under pressure. Advocates argued that these impairments limited his ability to participate meaningfully in his own defense or plead for mercy. But records from earlier years revealed long, articulate written statements from him, leaving questions about whether the communication difficulties were functional limitations or emotional exhaustion. The parole board unanimously recommended denying clemency, and shortly before the execution date, Ward withdrew his final federal appeals, another decision that ran counter to the idea that he was unable to articulate his own choices. At 12:33 a.m. on October 10, 2025, at the Indiana State Prison, Roy Lee Ward was executed by lethal injection. The procedure lasted 33 minutes, with no reported complications. His final statement, read aloud by his spiritual advisor, expressed remorse, self-loathing, and a hope that the Payne family might find peace. His last meal, chosen 10 hours earlier, included a hamburger, steak melt, shrimp, chicken Alfredo, baked potatoes, and breadsticks. Stacy Payne's mother has counted each day since 2001. Her father remains in the same home where everything happened, but chose not to attend the execution. Sheriff Keller, the first responder who locked eyes with Ward on the day of the crime, described the execution simply as the closing of a long and painful chapter. Do you believe this execution brought real justice? Samuel Lee Smithers, State, Florida, 72 years old. Samuel Lee Smithers grew up in Tennessee inside a household defined by strict religious discipline, rigid expectations, and a mother who believed unwavering faith could correct any flaw. From the outside, he appeared to embody everything a devout community wanted, a polite young man raised under the conservative structure of a deeply spiritual family. By 1979, at just 26 years old, he had risen to the role of deacon at East Ridge Baptist Church, a position that placed him in the center of community trust. But behind the quiet manners and church clothes lived a man with impulses entirely at odds with the image he projected. Long before he became a convicted killer, Smithers was already struggling with compulsive, sensitive behavior, eruptions of anger, and an obsessive desire to be admired. That desire twisted into something darker when he began setting small fires near his own church, racing to the scene as if he were the very person discovering the danger. When investigators eventually confronted him and he confessed, the congregation that had once trusted him turned away. The collapse of his religious facade forced him to leave Tennessee and seek a fresh start, but the same patterns followed him south. In the 1980s, Smithers moved to Plant City, Florida, built a marriage, adopted a son, and secured steady work as an electrician. The masks returned as well. He became a deacon at a new church, gained the trust of neighbors, but at night he drifted into the underbelly of prostitution, cheap motels, and drugs. His double life deepened when he began altering community service records for vulnerable women who traded sensitive favors for his help. In 1996, the facade collapsed completely. The first victim, Denise, New York, Roque, a young mother battling addiction, crossed paths with Smithers during one of his late-night encounters. He took her to a 27-acre property owned by family friend Marion Whitehurst, a place he had free access to through a gate key she'd provided. When police questioned him, Smithers claimed that Roach's death was an accident, that he had pushed her. A board fell on her face, and he simply found her dead the next day. But the forensic reality told a different story. Roach had been stabbed 16 times, her skull fractured, her face shattered, her body strangled, and then dumped into one of the property's ponds, where it remained for as long as 10 days. Nothing about that brutality resembled an accident. It revealed not only violence, but control, escalation, and the intention to conceal. 16 days later, Smithers killed again. Christy Cowan, once a promising student whose life had unraveled under the weight of addiction and instability, was last seen entering a truck matching Smithers's vehicle. What happened next was even more savage than the first crime. When her body was recovered, Cowan exhibited signs of drowning and injuries caused by axe. What broke the case open was a chance encounter. Marion Whitehurst arrived unexpectedly at her property and noticed Smithers washing a long-handled axe beside a fresh pool of blood. When she saw drag marks stretching from the garage toward the pond, something inside her shifted. She left the property, called authorities, and within hours investigators found the bodies of both Roach and Cowan submerged in the water. Smithers was arrested the same night. From the moment of his arrest, Smithers's story began unraveling under the weight of its own contradictions. The first explanation, accident, was obliterated by the autopsy. His second version, claiming he struck Cowan in a moment of panic and assumed she was dead, failed under the sheer force of the injuries. His third version, introduced during his 1998 trial, was a dramatic shift. He claimed that a mysterious group of drug traffickers had blackmailed him with compromising photographs, forcing him to leave the gate open as part of an illegal deal and making him witness, but not participate in the killings. Investigators could not find a single shred of evidence supporting the existence of these men. No witnesses, no photos, no phone calls, nothing. His final version again recast him as a victim, threatened, manipulated, terrified. Each variation contradicted the last, and none matched the forensic record, which showed clear, deliberate violence and concealment. The legal complexities surrounding his trial carried their own layers of conflict. Many in the community initially resisted the idea that a man so embedded in church leadership could commit such acts, a bias that investigators later admitted slowed early suspicion. The church's continued trust, even after misconduct allegations surfaced, created an image shield that protected him socially long after warning signs appeared. When the defense later attempted to introduce childhood trauma, rigid religious upbringing, and disordered sensitive behavior as mitigating factors, prosecutors countered with the argument that the killings involved planning, not loss of control. Appeals stretched for 26 years, raising questions about mental deterioration, declining IQ, and whether executing a 72-year-old man constituted cruel and unusual punishment. Ultimately, the courts rejected those claims, ruling that age alone did not exempt someone from capital punishment. On October 14, 2025 at Florida State Prison, the long legal process reached its end. Smithers declined a special last meal, declined a final statement, and died by lethal injection at the age of 72, with no family or spiritual advisor present. He left behind a legacy defined by contradiction, a man who preached faith yet inflicted terror, who wore the veneer of holiness while hiding impulses that consumed 2 women's lives. His case remains a haunting reminder of how fragile the boundary can be between devotion and deception, piety and violence. Do you believe faith can ever excuse such darkness? Lance Colin Shockley, State, Missouri, 44 years old. Lance Colin Shockley was born in 1981. Shockley was described by those who knew him as impulsive, easily rattled, and terrified of law enforcement. That fear intensified after 2004, when he became entangled in a fatal traffic accident that killed a young man. Although he was not charged at the time, investigators suspected that he had concealed key details. The case was reassigned to Trooper Sergeant Carl Graham, an experienced officer who pursued unanswered questions in the weeks leading up to Shockley's eventual arrest. To Shockley, this scrutiny felt like a countdown. He believed the investigation would expose a string of minor offenses, drugs, property violations, and old motor vehicle issues that he thought might send him to prison for years. Those close to him later recalled that he was convinced Graham would take him down, and his anxiety quickly evolved into panic. On March 20, 2005, that panic erupted into violence. According to the state's theory, Shockley drove to Graham's quiet neighborhood shortly before sunset and waited in the shadows near the officer's driveway. When Graham backed his patrol car into the garage and stepped out, he was shot multiple times with a shotgun at close range. The precision and brutality of the attack suggested an ambush. The shooter fled immediately, slipping through woods that bordered the neighborhood and eventually crossing into Arkansas. No cameras captured the crime. No neighbors saw the killer's face. For a period of hours, investigators had nothing but a dead trooper on his driveway and a list of people he had recently questioned, including Shockley. From the beginning, the forensic picture was startlingly thin. No DNA connected Shockley to the scene. No fingerprints were recovered from the spent shotgun shells. Despite multiple searches, investigators never located the murder weapon. The state relied instead on circumstantial indicators, cell tower data placing Shockley's phone near Graham's house, general similarities between the shell casings and the type of shotgun Shockley once owned, and the sudden disappearance of Shockley himself, who left home for 2 days following the killing. The most damaging evidence came from his on-again, off-again girlfriend, who told investigators she heard him say he had taken care of Graham. But her recollections shifted dramatically over time, first claiming he said nothing, then hinting he implied involvement, and finally asserting he admitted the killing outright. Defense attorneys argued her testimony was unreliable, fueled by a turbulent relationship, and unsupported by hard facts. Despite the case's reliance on inference rather than direct proof, prosecutors pursued capital murder. At trial in 2009, jurors heard about Shockley's flight, his fear of Graham's investigation, his prior behavior after the fatal accident, and the alleged confession to his girlfriend. But they also heard about the gaps: no gun, no DNA, no blood, no eyewitnesses, no definitive ballistics. After deliberating on guilt, the jury convicted Shockley. But when it came to sentencing, they deadlocked 11-1, unable to unanimously recommend execution. Missouri law, however, allows the judge to impose a death sentence when jurors cannot agree. And so, in a rare and controversial move, the judge sentenced Shockley to die. For the next 16 years, the case wound through every available legal channel. Shockley's attorneys argued ineffective counsel, insufficient forensic support, and the inherent danger of imposing the death penalty on a circumstantial case. State courts rejected the appeals. Federal courts reviewed the file and dismissed the claims, noting that appellate standards were narrow and the bar for overturning a jury's verdict was high. Requests to the U.S. Supreme Court were denied 3 times. Throughout it all, Shockley maintained his innocence, insisting he had been framed by assumption and fear. His attorneys highlighted that when DNA testing is unavailable, and when no direct physical evidence ties a defendant to a murder, the system depends heavily on human interpretation, which is vulnerable to error. By 2025, with his final appeals exhausted, Shockley's legal team and several anti-death penalty groups submitted clemency petitions arguing that executing a man without direct evidence set a dangerous precedent. They pointed to the girlfriend's inconsistent statements, the missing gun, and the unusual reliance on a judge rather than a jury to impose death. But Missouri's governor denied the request, stating that the courts had reviewed the case thoroughly and the verdict would stand. On October 14, 2025, in a quiet execution chamber in Bonne Terre, Missouri, Lance Colin Shockley was put to death by lethal injection. His final words were whispered and largely unintelligible, aimed at the family members seated behind the glass. His last meal, oatmeal and peanut butter, was among the simplest of any death row prisoner executed that year. Those who supported the execution said the state had finally delivered justice for a fallen officer, whose family had waited 20 years. Those who opposed it argued that killing a man without physical evidence risked repeating one of the justice system's oldest failures, mistaking possibility for certainty. In the aftermath, the case remains one of the most polarizing in Missouri's recent history, an example used both to defend and to condemn the death penalty. Supporters argue that indirect evidence can still be compelling. Opponents warn that circumstantial death sentences leave no room for correction. Between those two positions lies a question that refuses to fade. If a death sentence has no direct evidence, can it ever be truly just? And if the state waits for certainty, how long must a victim's family wait for justice? Charles Ray Crawford, estate Mississippi, 57 years old. Charles Ray Crawford's path toward death row began long before the crime that ultimately sealed his fate. Born in 1968 in Mississippi, he grew up in a household that was not impoverished, but deeply unstable, marked by conflict, substance abuse, and erratic discipline. By his teenage years, he had already drifted into violence, drug use, and the kind of impulsive behavior that made him a permanent fixture in local police reports. His marriage collapsed early. He bounced from job to job, and those around him described a temper that could ignite without warning. Later, his attorneys would frame these early years as the origins of a deteriorating mental state, citing mood swings, substance dependency, and a history of psychiatric evaluations. That pattern erupted publicly in 1991, when Crawford committed his first major violent crime. He lured his 17-year-old sister-in-law and her teenage friend into his car under the pretense of giving them a ride home. Instead, he drove them to an abandoned house in Walnut, Mississippi. Inside, he bound and gagged his sister-in-law, sensitively assaulted her, and attacked her friend with a hammer when she tried to flee. Both girls survived and immediately reported him, leading to his arrest. The case appeared straightforward, the violence undeniable. But in one of the state's gravest miscalculations, Crawford was granted bond and released while awaiting trial. That decision, the choice to free a man who had already demonstrated a willingness to kidnap, imprison, and brutalize young women, would prove fatal for someone else. On January 29, 1993, just 4 days before he was set to face trial for the 1991 attack, Crawford broke into the home of 20-year-old college student Christy Denise Ray. Investigators believe his original intent was burglary. Christy's presence inside the house was unexpected. But instead of fleeing, Crawford escalated. He abducted her, forced her into his vehicle, and drove her to an isolated barn. There he sensitively assaulted her and stabbed her once through the chest, a wound so deep it pierced her heart and left lung. He dragged her body to a wooded area and covered it with leaves, hoping the forest would swallow the evidence. Inside Christy's home, her mother later found a ransom note demanding $15,000, an amateur attempt at misdirection that became a pivotal piece of evidence when police found a nearly identical note hidden in the attic of Crawford's own house. Within a day, he confessed partially, claiming he had blacked out and could not remember the killing, though he admitted he must have done it. The forensic picture painted an even darker reality. Christy was found with her hands bound behind her back and tied to a cedar tree. A sock had been shoved into her mouth and secured with tape. Her pants were pulled below her hips. The stab wound that killed her was delivered with precision, not chaos. Dirt patterns and drag marks showed she had been moved while still alive. The crime bore unmistakable similarities to Crawford's 1991 attack: control, restraint, sensitive violence, and a methodical approach to harm. DNA confirmation left no room for alternative suspects. His 1994 trial unfolded with all the weight of those details. Prosecutors charged him with capital murder, assault, and burglary, presenting evidence that demonstrated not only guilt but premeditation. Crawford's defense centered on claims of bipolar disorder, dissociation, and memory loss, insisting he could not recall killing Christy and therefore could not have formed the intent necessary for capital murder. But 3 medical experts dismantled that argument, testifying that there was no credible indication of bipolar disorder or genuine amnesia, and that his behavior before, during, And after the crime was purposeful, the jury deliberated little before finding him guilty on all counts and unanimously sentencing him to death. What followed was a legal battle that stretched across 3 decades. Between 1994 and 2005, Crawford filed state appeals alleging impaired memory, coerced statements, and jury prejudice. Every claim was dismissed. Between 2005 and 2014, he sought federal habeas relief, arguing ineffective counsel and requesting new DNA testing. Courts found no basis to overturn the conviction. Then came the unexpected legal paradox. Because Crawford still had pending appeals related to the 1991 case, Mississippi was barred from scheduling his execution for the 1993 murder. For nearly 10 years, his fate remained in limbo while the courts resolved a conviction unrelated to the death sentence. Only after the U.S. Supreme Court rejected his final appeal in June 2025 was the state able to proceed. On October 15, 2025, at the Mississippi State Penitentiary in Parchman, the long-delayed punishment was carried out. Crawford woke early, met quietly with a pastor and family members, and accepted his final meal, a double cheeseburger, French fries, peach pie, and chocolate ice cream. When asked for last words, he spoke of love for his family and the peace he had found in God, offering a brief, almost gentle tone starkly out of step with the brutality of his crimes. At 6:15 p.m., he was pronounced dead. No complications were reported. For Christy Ray's family, the execution represented justice deferred far too long, a 3-decade ordeal that forced them to relive her death with every filing and every appeal. For legal observers, the case became a symbol of a death penalty system slowed to a crawl, where even the clearest forensic evidence does not guarantee timely resolution. And for those who opposed the execution, the issue was not guilt. Crawford's responsibility was never in serious doubt, but whether a justice system that takes 30 years to act can still claim to deliver justice at all. Which leaves one final question. If an execution takes 30 years to arrive, is justice still truly served? Richard Kenneth Jerf, State, Arizona, 60 years old. Richard Kenneth Jerf's life had been unraveling long before he crossed the threshold of the Wilson family's home in 1993. Born in Arizona in 1965, he grew up in an environment marked by alcohol, instability, and intermittent violence. By 17, he had already accumulated a criminal record: burglary, theft, street assaults, and by adulthood he had cycled in and out of jail so many times that incarceration felt more familiar than freedom. At the time of the killings, Jerf had just finished a sentence for armed robbery. He was unemployed, drifting between motels and abandoned houses, surviving off odd jobs and the occasional theft. His attorneys would later argue that a lifetime of instability and untreated antisocial personality disorder shaped his violence. That morning, Jerf walked to the home of Dawn Wilson, a woman who had once shown him kindness by offering food and small amounts of money. He asked for help again, but this time Dawn refused. Witnesses later described him as volatile, capable of switching from calm to furious within seconds, and rejection, especially from someone he believed owed him generosity, sent him into a rage. The confrontation escalated instantly. He forced his way into the house, overwhelmed Dawn, and seized control of the 3 children inside: 13-year-old Ashley, 12-year-old Jacob, and 5-year-old Christopher. What happened next was an escalating chain of calculated violence rather than a chaotic outburst. He tied the children together, threatened them with a knife, and dragged Dawn out of the house to her car. Terrified and injured, she was forced to accompany him to multiple ATMs, where cameras captured him looming over her as she withdrew cash. Jerf attempted to sensitively assault her inside the vehicle before driving her back to the house, where the horror deepened. The forensic evidence would later reconstruct those final minutes with chilling precision. Ashley's escape, her screams for help, and her stunning ability to describe what happened were the catalysts that allowed investigators to trace the killer within hours. The crime scene left behind was one of the most brutal Arizona detectives had seen in a decade. Forensic scientists quickly formed a wall of evidence around Jerf. His DNA was found on Dawn's clothing and on the ropes used to restrain the children. Shoe prints matched his worn sneakers. Fingerprints identified him as the person who handled the murder weapon and rifled through the Wilsons' belongings. A trash bin near the home contained blood-soaked clothing bearing both the victim's DNA and Jerf's. The ATM footage sealed the sequence. And then there was Ashley's testimony, soft-spoken, harrowing and unwavering, recalling how Jerf smiled as he stabbed her mother. By the time police arrested him hiding in a drainage tunnel outside Phoenix, the case was already overwhelming. But Jerf's own statements complicated the narrative. Across 2 decades, he offered 4 contradictory versions of what happened. In his first account, he claimed he panicked and could not remember anything. In the second, he insisted he only intended to rob the Wilsons and that the family attacked him first. The third version, offered at trial, suggested he was controlled by drugs and never meant to harm the children. The fourth, emerging in post-conviction filings years later, alleged that someone else had been present and committed the most serious violence. Each version unraveled under forensic scrutiny. Physical evidence placed Jerf alone at every stage of the crime, and investigators found no trace of an accomplice. Courts consistently ruled that the shifting stories reflected manipulation rather than memory loss. The 1995 trial became one of Arizona's defining death penalty cases. Jurors cried when shown photographs of the children, and Ashley's testimony at 13 years old, detailing the sequence of events, the threats, the sounds, and the final moments of her family, was described as almost unbearable to witness. Prosecutors portrayed Jerf as a calculated predator who escalated violence to eliminate witnesses. Defense attorneys tried to introduce psychiatric mitigation, arguing chronic trauma and an untreated personality disorder impaired his impulse control. But the court found that the planning, the ATM withdrawals, the restraint of the children, and the sequential killings demonstrated clear, intentional decision-making. The jury unanimously sentenced him to death. For the next 28 years, the case wound through every possible legal stage. State appeals challenged the admission of certain statements and argued ineffective counsel. Federal habeas petitions claimed Jerf's childhood trauma and mental health issues had been ignored. Psychological experts were brought in to reevaluate him, with new arguments raised about PTSD and a personality disorder. None of the appeals succeeded. The courts concluded again and again that the forensic evidence was overwhelming and that mental health claims did not approach the threshold required to undermine the sentence. By 2024, after the Supreme Court refused his final petition, the execution was inevitable. On October 17, 2025, at the Arizona State Prison Complex in Florence, Jerf ate his final meal: fried chicken, mashed potatoes, corn, and a vanilla milkshake. When asked for final words, he said softly, "I'm sorry for what happened. I don't remember everything." Ashley, now an adult who had spent decades navigating trauma, watched the execution in silence. Jerf was pronounced dead at 10:49 p.m. The case continues to raise debates about accountability, trauma, and the limits of mitigation. Even when childhood damage is undeniable, can psychological wounds ever justify or excuse the calculated destruction of an entire family? Across these 5 cases, one pattern becomes impossible to ignore: the rising severity of violent crime and the increasingly unpredictable nature of those who commit it. Each offender came from different backgrounds, yet all escalated from early misconduct to extreme, calculated brutality. Their stories reflect a broader national concern. Violence is not only more frequent, but more ruthless, more impulsive, and more devastating for families and entire communities. As the system struggles to keep pace, the question remains: how much worse must it get before prevention truly begins?